rally on behalf of Ms. Johnson, who's present to my right arm. And Smith, Assistant County Prosecutor, appearing on behalf of the people.
Okay, this matter was scheduled today, I believe, for violation and for sentencing. Let's see, I do have a pre-sentence report that was prepared, it's showing the 24th. Did you receive a copy?
Yep. Yes, we did.
We need to make corrections, updates, or deletions.
I believe it's a good action. Not the one of the people.
To make allocation.
My client, Ms. Johnson, is a young woman who I think has a very bright future ahead of her. She's working hard, both in her employment, also in her schooling, studying phlebotomy.
Can you speak up, please?
She's studying phlebotomy as well as being employed. She's working very hard to build a bright future for herself. She's turning 20 years old this week, Your Honor. Just what I'm trying to say is that I think she's a very young person who has some learning to try. She is working hard to improve herself, to build a bright future for herself. I certainly agree with the assessments and recommendations of the pre-sentence report. Now, I request that the court adopt those recommendations.
You finally want to make a statement today? I reviewed your prior criminal history, which there was nothing other than this, and then I also reviewed the pre-sentence report. There is the issue of the outstanding violation. I withdraw that at this time due to no further concerns as it relates to sentencing. It does indicate that she would be a good candidate for probation with a term of 769.4A and PIDA. Or there's a mistake or something that I need to write. Okay, so I'm gonna adopt the recommendation. I'm gonna place her on a term of probation for 10 months. Total period 769.4A and PIDA status. Gonna continue the no contact order. Thank you. A no contact order. You're not to have contact directly or indirectly with Chance Chandler. I'm gonna order that you maintain employment. And you're currently enrolled at LCC? Full-time or part-time? How many credit hours are you taking?
I'm not, so I did a semester and I'm not gonna do the summer semester right now, I'm gonna do the fall in person. They're not doing that.
Okay, so you did a you did a fall, the spring semester?
Yo,
How many classes did you take?
just,
One class. Okay. And then you're not gonna take any classes this summer?
no, but I'm gonna do 3 classes in fall, and they said 3 classes in the summer would probably be too much on me for the social thing.
The shorter time frame. Okay, so we'll take 3 classes in the fall. You are gonna be ordered to provide evidence that you are enrolled in the program. Okay? You're not to use, purchase, or possess firearm or weapons of any kind. You're not to engage in any assaultive or threatening behavior. You're not to use or possess alcohol, marijuana, or a controlled substance. I am going to order that you participate in random PBT in your analysis testing. You are responsible for the cost of that, okay? And I'm going to order that you participate in the WADE Domestic Violence Women's Program. Have any questions at this time? We're going to report virtually via Zoom for your monthly meetings with probation, okay? This is $30 per month oversight fee that you're responsible for, plus a $50 state minimum cost, $75 crime victim rights fee. Uh, 10 months of probation at $30 per month is $300. I'm gonna waive discretionary fines and costs. Okay, there's no restitution owed, correct?
That's correct.
Oh. And the total fines and costs is $475. You'll make monthly payments on it. Guess I'm having a party over there today. Still checking with probation before you leave here today. Are you on tether? Okay, you can go and have that removed. You're not eligible for early discharge because you are on probation for an assaulted crime, so I won't go over those rights. Any additional matters for the record?
Nothing from the people, Your Honor. No, Your Honor.
You're all set, man. That's vicious. Okay, this matter was scheduled for jury trial today. My understanding is that Ms. Thomas is going to plead to the charge and pay restitution.
Yes, Your Honor, I've spoken with defense counsel. After reviewing the file and the amount of the damaged product here, the people have amended the count to malicious destruction of property between 200 and 1,000. And the defendant has agreed to enter a plea to that charge and to pay restitution in the amount of $629 to Mr. Carl.
You're upgrading the charge?
Yes, Your Honor.
How's that a plea offer?
I don't think it's a plea offer. I think it's we should have charged that from that.
I recognize that. We're not doing that. This was offered for her to plead guilty to the charge and pay restitution. That's been the offer on the table. Not upgrading the charge today. The motion to upgrade is denied. She can plead to the charge, which is what it says, as charged, on the plea sheet, and she can pay restitution. But a motion to upgrade the charge today is denied.
Okay.
How does she want to proceed?
As that was our original understanding, we would like to proceed. I'll discuss I'll discuss her pleading to the charge of misdestruction of property less than $200.
Where's the restitution sheet? Is she agreeing to the amount of restitution?
Yes, Your Honor.
Who is this person in the back? Who is that?
Myself.
He's shaking his head. No, she's not. Ma'am, are you agreeing to the amount of restitution?
Yes.
Okay. How much are you agreeing to?
It's saying $200.
Okay, so it's $200 for restitution?
The item costs $629.99.
You're agreeing to pay $629 for the item?
I agree.
What is the item?
It's a firearm.
And it was damaged?
Yes, it was chiseled in half by the defendant.
I was protecting my daughter's life. I was figuring my daughter's life. It was a domestic dispute between.
Oh, well then why are we not having trial?
Because he said I need to plead guilty because the jury would find me guilty.
So that understand that I went over with this and asked her if she believed that she was guilty as we get to the factual basis. She had stated yes that she did believe that she was guilty. That was what we were proceeding under. I believe that what her explanation was an explanation for why she committed this act, but I don't believe that there was any.
What are the elements of malicious destruction of property?
Willful and malicious destruction.
And you understand the definition of malicious? Okay, and her position, I don't know the personal facts. That's what you all know. But she's claiming, at least on this record, that there was a domestic dispute and she was protecting her child's life.
I have the texts and I have been texting him to please just leave it alone, just stop it. He wouldn't, and he kept calling. I would have gave it back, but he didn't want it back until they was in that domestic dispute when he was mad and upset with her going over there trying to break.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Okay, you understand that you have the right to remain silent. Anything you say can be used against you.
I do.
You understand that you have the right to proceed to trial and be presumed innocent until proven guilty. This matter goes to trial. You can maintain your silence. The prosecutor has to prove each element beyond a reasonable doubt. If you plead guilty, you would have to give up your right to present any testimony or evidence of defenses that you believe you have to the charge. You give up your right to question or cross-examine any witness that they're going to call, and you give up your right to take the stand and give testimony. You understand that? Okay, and so your position is that there was a domestic dispute that you were protecting your child from. Are you saying that there was an active situation happening when you destroyed this, or allegedly destroyed this firearm?
Yes, I have Texas
there-
where he was
not-
trying to break in her house and he stole the camera, so.
I'm talking about at the
Oh.
time that you allegedly destroyed the item. Was it when there was an active domestic concern?
Yeah.
That you're saying that this person was actively seeking to assault your child in that moment?
Yeah, yes, during that time.
Not during that time, right now. He's getting the gun to shoot her right now. Do you want to get kicked out of my courtroom for talking out on my record? Then control yourself. You see this right here? You have control over it.
Can you repeat that, please?
There was an active threat at the time that you allegedly destroyed this?
But it was, yes.
Okay, you need to talk to your attorney. I can't accept the plea. You can figure out, I don't know what the threat was or if there really was one. If there wasn't, you need to explain to her why it wasn't an active threat. If there was, we'll call the case back after you speak to her. You've had an opportunity to have further discussion with your client. Does she wish to proceed today, or do you need more time to counsel her?
At this point, it is Miss Thomas's assertion that, this was an active situation. So, with that being said, we would like to proceed to trial.
Trial is already set or no? Oh, no, we have to reset it. If we wouldn't have been able to do it today anyways, because there's 2 trials going on. And we don't have any jury. July 14th at 8. July 14th at 8 a.m.
Your Honor, in light of the defendant's position, I would ask that the charge at this point be amended to the higher charge, and that we proceed on the malicious destruction of property from 200 to 1,000.
The motion is denied. Any additional matters for the record?
Nothing from the people, Your Honor.
Thank you.